Let's pass that real estate exam. You can do it, and you did it. So it's time to get that exam passed, your real estate exam. So prepare with lots of questions and, of course, your vocabulary, and more vocabulary. So today we're continuing with Monday's session, and the description below tells you where we're at in the book that I'm showing you on the screen, or that I will show you on the screen. Okay, so this is the book that we've been using. Excellent book. They have books for 26 states, and it is listed in the description below, and you can click the link and purchase it at Amazon. And when you do that, since I'm an affiliate member, Amazon will pay me a small fee. And anything that you purchase within 24 hours, I will get a small commission. All right. And so, hey, end of the year, time to get that mindset to pass. As the thumbnail says, right? You can do it. Pass now. So anyone watching the replay, you can fast forward between questions, as this class allows students to participate and type in the question and the answer. I explain the question, point out keywords, and also the answers, point out keywords, so that when you're studying and prepping or at the exam, you'll remember those little keywords that'll help you answer the right question, select the right question. So hi, Taylor. Wow, awesome. You're coming live. Hi, Johnny. Good morning. Okay, so let's continue with, let's see, we are on national questions. And let me see here. We're starting with 3.6. This is test number 6. So this book has, it has 10 national tests, and then it has, I think, 6 Texas tests, or 5 Texas tests. So all of these books have a national portion and they have a state portion. So if for some reason they don't have the one for their state, buy a national, buy one that has the national, or, find another one. I have several that I describe in the descriptions. Okay, so let's get going with this. And so I'm really excited that you're here on Christmas. No, not Christmas, New Year's Eve, right? So it's a beautiful day here in San Antonio, Texas. So remember to type the question number and then the letter answer. Okay, these questions are dealing with land use, legal descriptions, and contract law. Every state has contract law in the national portion of it. And then, of course, you have your specific state laws on the state portion. In Texas, we do 2 exams, one for national, one for Texas. Other states, they combine it all together. All right, so we're starting out with number 3.7, and again with land use, legal descriptions, and contract law. Actually, we're starting with 3.6. So at any point that you have a question, hey, type a question in the comments, and I'll take time to answer it. And don't be shy, okay? This is the time to practice and type your answers and see if you've got them correct. I went through the same thing, okay? I had fear of multiple choice questions, so I totally get it. All right, number 6. How does planned unit development, abbreviated PUD, okay, they call it a PUD, planned unit development zoning, vary from ordinary zoning? So A, it applies only to office parks. B, it incorporates a number of different zones within a single property boundary. C, it requires that multiple tracts of land be developed according to a single design. Or D, it requires developers to obtain a separate building permit for every structure. Whoa. So type your answer in the chat. All right, we have Johnny with B. It is not B. So how does a planned unit development, PUD zoning vary from ordinary zoning? So the answer is actually C. It requires that multiple tracts of land be developed according to a single design. All right. It says planned unit development zoning requirements used to development of whole tracts that are designed to use specific efficiently and maximize open space. A PUD zone may be for residential, commercial, industrial, or a combination thereof. So you could have like your own all-inclusive community, and that may be a PUD. Okay, as it says, it can have residential, industrial, that's for, businesses, manufacturing, things like that. And also a combination of the two. So almost, except for agriculture, right? So you have almost all the different types: residential, commercial, industrial, and or a combination of them. So they have to use the same design. Hold on, I forgot to put my phone on Do Not Disturbs, and all these little blings are coming in. Okay, so, and you all chose B. It incorporates a number of different zones within a single property boundary. No. So that means you have all of this PUD onto one lot. You see, it says within a single property boundary. So look at what the question asks. So a planned unit development. So it's a development. A development is going to be more than just a lot. Okay. It's going to be, various pieces of land, parcels, lots, sections. Okay. Because you could have residential, commercial, industrial, a combination of them all if it's in a self-contained community. So it is not for office parks, okay? It's a planned area development, okay? So think of an all-inclusive little town, a suburb almost, okay? However, it's smaller than that. So it requires that multiple tracts of land, so different parcels, different acreage right next to each other, be developed according to a single design. Okay, they may have their own, like there's also a MUD, municipal unit development. This one is a planned unit development. The other one can be used for like 55 plus, other types of unit. They have their own sewerage, their own water, and they have almost like a homeowner association. So again, let me repeat the answer here. And the reason why B is not, it says different zones within a single property development, boundary. And it's actually multiple tracts of land developed according to a single design. Okay, a single design for multiple pieces of land versus many zones, okay, within a property boundary. Okay, so C, it doesn't incorporate, okay, it requires multiple tracts of land. So 3-6 is C. Now, any questions for those of you that answered B? And for any of you who've just came in, we're doing national questions that apply to all 50 states. And we're dealing with questions for land use, legal descriptions, and contract law. So thank you for joining us, and let me know who's here. Type a comment so that we all know who you are. Hey, good morning, Miss Lisbeth. Gosh, I was almost typing B on here because everybody typed B. Okay, I'm trying to get all squared away on Facebook also, because some of you may watch on Facebook, and I am streaming. I'm a streamer, I'm a YouTuber. Kind of like, I'm a pepper, you're a pepper, we're all a pepper. Dr. Pepper used to be one of my favorite soft drinks besides Coke. However, I rarely drink soft drinks now. All right, number 7. Hi, Renee. Thanks for joining us. Let's see what he says. I just took my exam this morning and passed both. Woohoo! Congratulations! Oh, an awesome way to end the year. Oh my gosh, how exciting, Renee. Wow. Check it out, y'all. He just passed both exams on New Year's Eve day. Fantastic. And that was his first time. Would you type in the chat what you studied, how often you studied? So what you studied, how often you studied, and how soon after you finished all your classes, so that you can encourage and share with others your experience. So Johnny says, congratulations. Renee will absolutely comment on here. All right, number 7, right? Yes. That's so exciting. Ooh, ooh. Even more reason to celebrate, right? Okay. Which of the following situations is most likely to represent an illegal non-conforming use? A, homeowner in a residential zone converts her residence to a private school. Okay, so let's go back to the question. Which of the following situations most likely represents an illegal non-conforming, so vocabulary, good morning, Cindy, non-conforming, okay? So there's a zoning and this property doesn't conform to it. So A, homeowner in a residential zone converts her residence to a private school. B, a homeowner builds a tool shed in a neighborhood where there are no tool sheds. C, a store owner remodels a storefront in accordance with regulations, and then the zoning is changed to residential. Sorry, you guys. I'm over here snapping my fingers to my cats because they're trying to get into the other cat's bowl, and I'm a disciplinarian. And I'm snapping my fingers, and they're getting all startled here. Okay, they're right next to me. So sorry about that. I'm an animal lover, okay? They crack me up. Okay, where were we? So which one is illegal non-conforming? C, a store owner remodels a storefront in accordance with regulations, and then zoning is changed to residential. D, a new zoning ordinance outlaws 2-story additions after a homeowner completes an addition. So which one likely represents an illegal non-conforming use? So you have zoning that we're required to meet in a city, in a county, within a subdivision. So first we have to meet the conditions of the zoning area. Is it residential, industrial, commercial, agriculture, whichever it is? And then if we have, and so we must meet that, and we can't go astray from that. Otherwise, we're going to be illegally non-conforming, and zoning can come and say, hey, that's not allowed. You got to take it down, no matter the cost. Okay. Other things can be acceptable if the zoning changed. However, there is what is grandfathered in, something that already existed. Okay. So type your answer. Okay, we've got Taylor with A, Lisbeth with A, and Johnny with A. And yes, that is the correct answer. A homeowner in a residential zone converts her residence into a private school. Okay, no, right? It's residential. It's not variable zoning. So it must stick with residential. In order to try to do something like that, they have to go get approval. And because neighbors may not want to have, a school right next to their house. So that's what zoning does. It controls the use of land within an area. And so it controls also the density. How many homes are you going to have within an area and on what type of land? Now, churches are an exception. They can be built pretty much anywhere. Okay. But everyone else, consumers, for the public, it's to control and protect the public and the growth and the plan of the area, of the city. So let me type the answer and then I'll go back to comments. 37A. Okay, I want to see what comment. So Renee says, I've been going through the classes for about 10 years off and on, but for the past 2 months, I've been using multiple YouTube videos. Awesome, including yours and the files on your Facebook media. Fantastic. That's what they're there for. And so you see, 10 years ago, something he really wanted and he did it. And he started watching multiple videos. Different teachers, different tutors, different individuals have different styles that accommodate you. Look and see what, learn something from each one. And says the best one was your file on what to read before the exam. Oh, awesome. That's great. I'm trying to think what it's called. That one is in my Facebook group. It's not here on YouTube. So we have a private Facebook group and I have some documents there to read the night before the exam. I think it's called something like that. Excellent. Thank you for sharing. And he added the link here. What is that? Users Cash America downloads. I'm not, night before. That's it. Night before the exam cheat sheet. Yes, I've had other students also use that. So anybody can click that. And that's actually in the private Facebook group. If you're a member, if you're not, these are streamed into the private AgentPrep Facebook group. And in order to be approved, you need to put your name, your email, and follow the rules. And if not, you're booted out. Can't follow rules now, you're going to struggle in the real world. I mean, rules are, my daughter calls me a rule breaker, right? Because the CEO of Motorola, when I was an engineer, I was wanting to get relocated. And they kept telling me, no, we can't break that rule. Never happened before. You're a beginner. There's no way you're going to be transferred from Arizona to Texas, where everybody wanted to go. And so during the interview with him, he says, sometimes rules are meant to be broken. Depends on the rule, right? So sometimes they are meant to be broken. That's fantastic, Renee. So it says, I started to at least once a day going over the Texas and national practice exams. Fantastic. It says, I can't wait. I'm so close. Yes, do it. So you see what he says here? The vocabulary really helped for weeding out wrong answers that I didn't know the correct answer for. So that's why I'm stressing now on the questions. Okay, what is non-conforming? Illegal when it comes to real estate. Residential zoning. What is zoning? There's different types of zoning. What is the ordinance? So, having an addition. What's a storefront? So all these regulations, all these are vocabulary. That's why I keep stressing it. And other instructors that are realtors that do this or brokers, they also stress vocabulary. So it's like the saying goes, what part of vocabulary don't you understand? So it says, you guys can do it. If I can do it, anyone can. Woohoo! Awesome! Yay! So proud of you. Thank you for persisting, sticking with it, and making it happen. And it looks like you're in the military. So thank you for your service. So way to go, Renee. Oh, so now it's time to select a broker, right? Review it. Oh, I actually put a short on there about, how to get your real estate license. And at the end, I said, interview different brokers, okay? Whether it's a virtual company or it's a brick and mortar company, okay? I work with a virtual company, EXP. There are many good brokerages out there. I would love to have you at EXP. We may not be the company for you. So interview different one. And you can schedule, I think in my link, I have a Calendly link that you can schedule a 30-minute with me or longer. And we can talk about, the benefits and what is offered with EXP. I'm not a pressure type of person. So, I want what's best for everyone. All right, excellent. Great news to end the year. And more great news. I closed the transaction yesterday, $300,000, woohoo, and got paid on the same day. That doesn't always happen. So when it does, it's awesome. Okay, number 8. I know anybody watching the replay, hey, fast forward. I get so excited for different things. I'm passionate about this. And, I'm a high energy. That's why I go by Wild Lillie Handy. I'm the wild child of the family. All right, 3.8. Yay, yay, yay. So he is retired. Awesome. All right, let's keep going. Thank you for sharing, Renee. Greatly appreciate it. Let us know what city you're at. What is the difference between a variance and a non-conforming use? And the state, right? Because this is national. So what is the difference between variance, vocabulary, and non-conforming use, vocabulary? A variance once granted is unconditional and permanent. B, a variance is granted for the zoning board by the zoning board if the owner has a justifiable reason. C, a non-conforming use is allowed if the owner requests it in advance of building. D, a non-conforming use violates current zoning, but a variance does not. So what is the difference between variance and non-conforming? Okay, so A says a variance, once it's granted, is unconditional and permanent. Okay, so B says a variance is granted by the zoning board if the owner has a justifiable reason. Okay, C, so kind of makes sense. C, a non-conforming use is allowed by if the owner requests it in advance of building. Well, then what's the use of zoning, right? And usually you have zoning laws you have to follow. Oh, sorry. And then D, so what answers do we have so far? None yet. A non-conforming use violates current zoning, but a variance does not. So which one is the correct answer as to the difference between variance and non-conforming? Love that. All right, we've got B from Lisbeth and Johnny. Who else? Anyone else? Bring it on, bring it on. Come on. Come on, come on. Type them answers. All right, the answer is B. A variance is granted by the zoning board, and they're actually called the adjustment board. Okay, it has to go be a request has to be submitted for a variance, and it has to be justifiable. So once a variance is requested, the zoning board and the adjustment board, they send out notices to the surrounding neighbors and have then a public meeting to have both sides, neighbors and the actual person requesting it, come and share their reasons either to approve it or disapprove it. If the neighbors have no issues with it and the zoning board, variance adjustment board, because they're adjusting a zoning, right? So, and the reason why I'm calling it adjustment is because I've been to an adjustment board meeting for a client that I had, a developer, to make a change, and it was justifiable. That justifiable reason was also going to bring additional money to the city. Okay, because if they allowed it, and it was for the setback in the back of the property and the setback in the front, because the lots were a little small. And so it was approved. It was going to bring, more property taxes into the area, more money to utilities. So it was a good decision. So it has to be an adjustment, okay, a variance, a change to the zoning of that particular lot, that area. So zonings variances are permitted, okay, and they go with the land. And nobody answered the others. Nope. Okay. Number 9, a document certifying that a structure complies with building codes and is ready for use is referred to as an inspection report, B, a satisfaction bond, C, a certificate of occupancy, or D, a user permit. So a document certifying that a structure complies with building codes. So building on that piece of land, on that lot, okay, it complies with it and is ready to use and ready for use is referred to as A, an inspection report, B, a bond, satisfaction bond, certificate of occupancy, or D, user permit. Okay, so document that certifies that a structure, a building, complies with the building code and is ready for use. So what do you refer that to? Awesome. So Miss Cindy and Johnny have selected C. Lisbeth, C. C, oui. And yes, the answer is C. That is a certificate of occupancy. This is for new construction. Okay, so the city inspectors will go on different stages of the development, okay, to the plumbing, digging out the plumbing, and then treating the land, the concrete for termite, all those phases. A city inspector has to come and inspect every stage of the development, from plumbing to laying the platform, okay, the foundation, the setting, then the concrete, every stage, okay, that they build. An inspector comes to make sure they are following zoning codes, building codes. Very good. There's a lot that goes into it. So let's see what it says here. It says building inspectors inspect a new development or improvement for code compliance. If work complies, the municipality or county issues a certificate. Okay, so municipality, the city, or county, right? They might be building in the county. There's less restrictions in a county than there are in the city. Issues a certificate of occupancy, which officially clears the property for occupation and use. So before anybody can go and live in a property or start a business in a building, it has to meet all these building codes and be safe for whom? The public. All these things are done to protect the public, okay? and the city, the structure, the plan, the growth. All right, number 10. So they start having like a 5-year business plan. You know, cities have that. And they have an economic development board or council that is in charge of the growth and development of the city, of who they're letting in, who they're not, providing taxes, exemption or reductions, benefits to bring businesses in. So a lot of this doesn't happen overnight. It takes years. Okay, like for McDonald's, Burger King, Walmart, you know, Target, all these major businesses that come in, gas stations, they plan years in advance. And how do they decide to buy the land? Well, they look at the city's business plan, the development plan that the Economic Development Council together with the city, you know, bring together. All right, number 10. Which of the following is true of an eminent domain? Vocabulary. Proceeding. A, it cancels the property's owner mortgage loan balance. B, it leaves the property owner with equitable title in a place of legal title. C, it conveys legal title to the acquiring entity. Or D, it clouds the chain of title by canceling the original grant. Okay, so vocabulary. Property owner mortgage, equitable title, legal title, conveys, acquires entity, cloud of chain. Okay, all those are vocabulary in one question and answers. So what is true of an eminent domain proceeding? So it is one of the what police powers, right? So it kind of goes like whether the owner wants to do it, accept it or not, they will have to convey it, but they are compensated for it. Yes, the answer is anybody else? The answer is C. It conveys legal title to the acquiring entity. Okay, because eminent domain is when, you know, the police powers, the city needs land for public use. They're expanding, fixing the roads, widening the roads, sidewalks, plumbing, you know, all those type, electrical. So they need more land, right? And therefore they end up taking over land and from an owner at a market valued price. So they can't just take over and not compensate the owner. The owner has to be compensated. And so they call it condemnation. They condemn the piece of land that they're going to take over based on the city plan, okay, the master plan. And the owner can do inverse condemnation, right, and object and go to court. However, if it's part of the land, I mean, part of the plan for the community, for the city, it's going to be very challenging. So the owner might say, hey, it's worth more than what you're willing to pay me. So then that they go to court and come to a decision on that. So the legal title, okay, is being transferred. All right. So just to convey, right? You're transferring from one owner to another, right? And so a title, okay, is not a physical document, but rather a concept. I mean, we do have a physical title policy, okay, that is issued by a title company. However, it's not a physical document, but rather a concept that is conveyed through a property deed. The ownership of the property, right, comes into a warranty deed, be it a quitclaim deed, special warranty deed, or guaranteed warranty deed, or general warranty deed, okay? So the property deed, okay, that's the official document. That's the instrument that shows legal ownership of a property. Okay, and then let's see. Legal title is the actual ownership of the property as when the property has been bought. Okay, that's what that is. So you see how many vocabularies you had on there? You know, mortgage, equitable, conveys, legal, title, acquiring, entity, clouds. All these are vocabulary. So very good for those of you that answered C. It conveys legal title to acquire an entity, eminent domain. Okay, eminent domain is the right to take over land. Condemnation is the action to take over the land. Okay, and then equitable title, right, is a form of ownership or right of use that exists without legal title to the property. So banks will have sometimes equitable title, and sometimes owners will have, depending on the states. Okay. All righty. So did I put it on Facebook? Yeah. All right, number 11. So there's a lot that goes into understanding a question and its answers. And as Renee mentioned, the more you understand the vocabulary, know the vocabulary, the better you're going to do at answering a lot of these questions. Number 11, among other provisions, the Superfund Act, known as CERCLA, and Superfund Amendment and Reauthorization Act of 1986 provides that A, large development projects undergo an environmental impact survey immediately after completion of construction. B, industrial users of real estate comply with air quality standards. C, the EPA would give financial help, the Environmental Protection Agency, give financial help to homeowners to remedy any hazardous situation resulting from radon, asbestos, or lead-based paint. Or D, parties responsible for improper disposal of hazardous waste could be charged for the cleanup costs. And yeah, there's a lot of times, a lot of cost involved for hazardous stuff. Oops. It is not C. Hi, Anai. The answer is not C. So take another attempt. All right, so you have D. Yes, the answer is, well, I'm going to give you an opportunity to do more. Let's see here. Yeah, the answer is D. Sorry, I got distracted by door knock. All right, so number 11. Okay, CERCLA. What does CERCLA stand? So among other provisions, the Superfund. Hold on, y'all, just a moment. Hi, I'm teaching a class. I'm teaching a class. Yeah. I'm gonna go right now. I'll come back. Okay. So the Superfund Act, known as CERCLA, CERCLA stands for what? Comprehensive Environmental and Response Compensation Act. So it deals with comprehensive overall major, okay, environmental response, compensation, and liability act. So the among other provisions, so the CERCLA and Superfund Amendment and Reauthorization Act of 1986 provide that parties responsible for improper disposal of hazardous waste could be charged for the cleanup costs. Okay, let's see. We had C and A. So A says large development projects undergo an environmental impact survey immediately after completion of construction. No, it would have to be prior, not after. That's a lot of money being invested to have a development and not evaluate, inspect, okay, the environmental impact. So that has to be approved by the city, the county planning, as whatever type of business that's going to be. It has its rules, its zoning codes, development requirements. So everything has to be approved and see what kind of impact it has on the environment, on the public. And then we had C. C says the EPA, Environmental Protection Agency, would give financial help to homeowners to remedy any hazardous situation resulting from radon, asbestos, or lead-based paint. No. So EPA, all right, you want to go and review, okay, what EPA does. So that's an Environmental Protection Agency. So they're known for regulating the environment, protects people and the environment from significant health risks, sponsors and conducts research, and develops and enforces environmental regulations. They do not provide money for, cleanup resulting from radon, asbestos. So insurance can cover, these things if you had a home with those things, or you're having to pay a major cost to have that removed. So vocabulary, go back and review your vocabulary. All right, number 12. Let's see if I can get it on the next page. And so I have 3 monitors going on. Okay, y'all, so I'm turning left, middle, and right. Okay, so number 12. Public land use planning. Public land use planning strives to balance which of the following potentially conflicting interests. So we have a planning department that's involved with zoning, and they control, sewer, water, electrical, okay, all the codes that have to be met to be safe for the public. So public land use planning strives to balance which of the following potentially conflicting interests? A, individual property rights and the public's interest. B, public policy makers and community business leaders. C, tenant occupancy specifications and construction contractors. D, individual property owners and municipal planning agencies. So public land use. So how is the land where people live and going to be used? So that, like I mentioned, a master plan, they could have a 5-year, 10-year, 15-year master plan for the growth of that particular city, metro. So public land use planning, the planning department strives to balance which of the following potentially conflicting interests? It is not D. Take another attempt, Miss Cindy. And by the way, Miss Cindy already passed her national exam and she still attends. So I thank you for that. So, public land use. How are we going to use public land? And it's not C, Johnny. So it's not property owners conflicting with municipal planning agencies. Two separate areas, two separate things, okay? Individual property owners have a lot and the improvement. A municipal planning agency, okay, you're going to have a little bit more independent type of planning area. Yes, the answer is A, individual property rights and public's interest. So the optimum management of real property usage must take into account both the interests of the individual and the interest of the surrounding community. That's why they have zoning and to control, conforming and non-conforming use. While maintaining the value of an individual's estate is important, that means your interest in this real estate property, the owner of an estate must realize that unregulated use, that's why we have zoning, and development can jeopardize the value, not only the owner's estate, but of the neighboring properties. So someone starts to, do something on their piece of land that is not according to the zoning, or if it's in a subdivision, not according to their deed restrictions, because those are going to be tighter than the zoning. Developers have to meet zoning to implement their development, and then they can create tighter restrictions like, hey, we want 2-story brick homes. We want 2-car garage. They have to be 3,000 square feet, no less, okay, or greater. And you can't have any obstructions, any, sheds or any things like that. You can't park your trailer. You can't park your boat, or things like that. They have very tight restrictions in that community. Okay, so any impact like that, okay, building a high-end fence that's going to interfere with the view of the other owners, that's going to deter when the neighboring owners want to sell. It's going to be hard because they don't want this humongous fence hiding their view. Okay, so it ends up impacting the value, the resale value, the marketable value of that property. So individual property rights and the neighboring individuals, right? The public interest. That is public planning planning strives to balance, so it is there to control how development grows, what is put in a piece of land, what cannot be put in a piece of land, what is allowed, what is not allowed, and how it impacts the value of those neighboring homes. So if you have someone that ends up bringing a manufactured home because the city said, yeah, manufactured homes are allowed there, but not in that particular subdivision. Well, bringing a manufactured home to a piece of land that they bought in a subdivision and they're not following the deed restrictions, which are tighter, that's going to impact the property value of those other neighbors. So no, they'll end up going to court and have them remove it. Okay, so there are controlling things there. So public land use. How can the public use the pieces of land and be in balance with the other individual's interest and not negatively impact anyone else? Now, you start remodeling your home, you start making improvements, you improve the curb and gutter, the exterior, new roof. Those are improvements. You tear it down, build a new home, but you're meeting the zoning and the building codes. That's improving, that piece of land, and it'll impact positively the neighboring properties. And so then it kind of rubs off on the neighbors and they start doing similar things. Okay, for example, I bought a piece of property in South Texas. Okay, little house, the smallest house in the neighborhood, but I loved it. It was all inclusive. It was totally furnished. It was out in the country, and I moved from Oregon, so I loved being out in the county. It was near agricultural land. Well, what did I do? I came in and I put massive concrete, okay, around the house so that I could have abundance of parking for when my family came and I wouldn't be interfering with neighbors and parking on the street. I added sod, okay, nice greenery view in the front. I added a sidewalk. I added a humongous carport. So then neighbors start and improve the fencing. Neighbors started to add fencing, started to add more grass, started to add more driveway. It started to improve the neighborhood. All it takes is one. So long, oh my gosh. Oh my gosh, I typed the wrong answer. Hold on, let me correct that answer there. I got carried away here. I saw somebody's answer and I typed that. So anybody watching the replay, 312 is A, not D. So this is the answer, 312A. Okay, disregard. Let me see, can I eliminate? So let me type 312A again on Facebook. So answer is A. D is a typo. Okay, so answer is A, D is a typo. So did you all get that? Because you had answered D and C. So the tenant occupancy specifications and construction contractors, that's for the developers that are developing apartment complexes, fourplex, duplex, and they're going to rent. So they've got to meet, zoning codes where they can build those. They can't build them in every single residential 1-unit lot. So it's not tenant occupancy specification. There are extra landlord tenant laws that control that. So for having, if they're going to be renting, okay, they're going to be in a different probably zone if they're going to have multiple units. A zone that allows duplexes, triplexes, fourplexes, and those are still considered residential. So certain residential, according to the density plan of the city, are going to allow fourplexes. And then you'll see other lots, other parcels that have fourplexes or duplexes, but they're not going to be typically right next to a single residence home where you can only build one residence. So it's public land use planning to balance which of the following conflicting interests. It's the individual rights interest and the public interest. All right, excuse me here. So look at the words carefully, okay? And start to think, expand your thought to common sense and put yourself out there, stand in the street and think about it, okay? All right, number 13. Zoning, building codes, and environmental restrictions are forms of local land use control as A, master plan, B, preemption, C, police power, or concurrency. So zoning, building codes, environmental restrictions are forms of local land use control. And who controls those? Is it the master plan? That's a plan. Preemption? C, police power? Or D, concurrency? Okay, Miss Cindy has C. So anyone that maybe just came on, we're doing national questions dealing with land use, legal descriptions, and national contract law. So yes, the answer is C. It is police power. Okay, zoning, building codes, and environmental restrictions is one of the police powers, right? Zoning. Eminent domain is another one. Okay, so 13. Let's see. So very good. Okay. Okay, since we mentioned police power, who can name 2, 3, or 4 of the police powers? There's 4. Okay, there are 4 police powers. Can anybody remember those 4? Type those in the chat. I'll give you one for free, right? And it goes by Pete, right? P-E-T-E. So the city has control, okay, by using 4 powers that they have, right? Which are Pete. So what does Pete stand for? Typing them in the chat. Taxation, yeah. Eminent domain is cheat, very good. And police power, right? So Pete, police power, eminent domain, taxation, and escheat. And escheat is what? When someone dies without heirs, right? And without a will, it goes to the state. So let me type here. Forgot to copy and paste. So hold on. So very good. Yeah. So you see we have their eminent domain, escheat, taxation, and all 4 of the police powers. Okay. And so police powers are the right to regulate land use through a general plan and zoning. And so I'm looking at some other examples. So examples of federal use of police power are food and drug regulations, environmental preservation laws, and workplace safety laws. And remember, part of the police powers, right, with the use of land are the easements, right, for utilities, utility easements. Okay, number 14. And so we went through eminent domain, right? Taking land for public use. Okay. That is the right to take land for public use is eminent domain. The action to take land for public use is what? Condemnation. However, the owner has to be compensated according to market value. So that was eminent domain. Taxation, property taxes. We never own a property 100%. because we have to pay property taxes, and we can lose our property should the property taxes not be paid. They can foreclose on it. So those are tax deeds, right? A property can be sold for property taxes. Investors like to buy that. And then if the owner wants it back, they've got to pay penalties and interest, 25% a year, to get for 2 years. There's a right of redemption, right, for 2 years in order to be able to get their land back and pay for the property taxes. And then we have cheat. So with far as property taxes, a military veteran that's 100% disabled does not have to pay property taxes. They are exempt from property taxes. And then cheat. When a person dies without a will and no heirs, it goes to the state. Okay, so those are the PEAT of a city, okay, to control the use of land for public interest. Number 14. If municipality exerts its power of eminent domain against a certain property owner, what happens? Just discussed it, right? A, the owner must pay higher property taxes or give up the property. B, the owner must cede an easement without receiving any compensation. C, the municipality annexes the property. Or D, the owner must sell the property in exchange for market value compensation. No, it is not C, Miss Cindy. Take another attempt. So eminent domain, taking property for public use in exchange for compensation. D, that is correct. So the answer is D. The owner must sell, okay? Must, not an option. Sell, that's one of the powers, okay, that the city has, the county, the state must sell the property in exchange for market value compensation. Again, eminent domain is the right to take land, property for public use, land, portions of it, and condemnation is the actual act of taking over the property, condemning the property. All right, number 15. Oh, I went the wrong way. Okay, very good. So anyone who just came in, we're doing national questions that applies to all 50 states, having to do with land, legal descriptions, and contract law. That contract law that is national, not state specific. 15, to be valid, a local zoning ordinance must, okay, to be valid, a local zoning ordinance must A, reasonably promote community health, safety, and welfare. B, comply with federal zoning laws. C, apply only to unique properties. Or D, publish periodically in the local newspaper. So type your answer in the chat. Come on, come on. Nothing. A, B, C, or D. To be valid, zoning ordinance So these rules and laws are designed and created what? To protect the public, right? So A, must reasonably promote community health, safety, and welfare, right? They're dealing with environmental laws, make sure there isn't any hazardous waste, right? No major negative impact that could affect the health of individuals, right? Safety, roads, areas, stop signs, lights, sidewalks, everything that goes into it, and the welfare of the individuals. Okay, prevent high density in an area where the structure can't sustain it. That's why we start having a lot of flooding, because the structure, of the city, doesn't have enough area for water to flow out. So now you see a lot of major businesses and gas stations, they have this reservoir area, and you're like, what is that hole there for? That's a reservoir for excess water, whenever there's a flood, so it doesn't flood the actual business. So it has somewhere to flow in the meantime as it gets discharged into the sewerage system of the city structure, of the city's foundation plan. Okay. Hi, Delta. So he says here, is it true that Houston doesn't have any zoning? Delta, I can't answer that, as I'm not familiar with Houston zoning. However, as far as I know, every city has to have zoning. Otherwise, they wouldn't know where, what, when, how to develop things, around a particular city. So, there has to be zoning everywhere. I don't know how that could be true. All right. However, I have no experience with Houston zoning. So let's see, I can Google it. And, how would they control the development and the growth, of a particular city? Well, very interesting. So they have something different. So the city of Houston does not have zoning, but development is governed by ordinance codes that address how property can be subdivided. So they have the Planned and Development Department. Okay. So it's a greater, they don't have what they call a zoning letter and boundary map. So they have the Department of Planning Development regulates, the land development in Houston and within its extraterritorial jurisdiction. The city of Houston does not have zoning, but development is governed by ordinances. So instead of zoning codes, they have ordinance codes, and that address how property can be subdivided. City code do not address land use. So it says the department checks subdivision plats for the proper subdivision of land and for adequate street of right-of-way, building lines, and for compliance of Chapter 42, the city's land development or ordinance. So they may not have zoning codes, but they have ordinance codes. So they have municipal codes and ordinance regulations. So they do have control of land use. It's just called ordinances instead of zoning. Good question, by the way. All right. And I wanted to go back to the prior question, all right, number 14, and stress a little bit more about eminent domain before we go to Texas questions. Because I went and looked at their answers. So I just wanted to say, so the answer here, was D, right? The owner must sell the property in exchange for market value compensation. And so they say eminent domain, it's a government right? It's a right of the government, the city, the county, the state. It's the right of government entity to purchase a fee, leasehold, or easement interest in privately owned real property for the public good, regardless of the owner's desire to sell or otherwise transfer any interest. In exchange for the interest, the government pays the owner a just compensation, okay? A justifiable compensation according to the market value. So it could be a leasehold, an easement, or purchase a fee, okay? So just wanted to go back. So it has it in different ways, but it's a government entity. Okay, it's a government power that they can take land or leasehold or purchase a fee for public use in privately owned real property. Real property, land and its improvements, or just land. Okay. All right. Any questions on these national questions? And so if you're wondering what I use Kindle because it allows me to download the book I have permission to use. So I'm going to put here, we're going into Texas state questions. Oh, no questions. Okay. So by some of the answers today, okay, lets me know that it's very important for many of you to go back and review your vocabulary, because that vocabulary is also going to help you in state questions, state-specific questions. Okay, no. Let's see here. Let me see what question we're starting with. We're starting with test number 16. Those are kind of mix and match, and so it's more difficult to do those in a session like this. However, should you own the book, I recommend that you do that section of test number 15. You know, they give you the, you have to like fill in the blank. It's matching. They give you all these topics, all right, A, B through Q or through R, and then you fill them into the blank. All right. So this was number 16 here. So we're now in special topics for Texas real estate. Getting there, getting there. Bear with me here. Oh, come on. Okay, here we go. So Delta, you must live in Houston, right? You know, be very careful what you hear. You might say, well, gosh, they have no controls. Well, wrong. They do have controls, okay? They use ordinances. So there are ordinances and zoning, and it's government controls. You know, part of the PEAT. All right, so have one more thing here. Got to make sure I've got my answers in place so I don't mess it up, right? And give you a wrong answer, because we're human, right? Tutors, realtors, individuals, humans, we make mistakes. All right, number 16, special topics in Texas real estate. You have a section where you studied about special topics that they couldn't put in something else. So number 1, Texas is a community property state versus tenants by the entirety, right? In other states. So community property state, effectively, this means that A, once married, all property in both estates are owned equally between husband and wife. B, upon legal marriage, all property becomes owned as tenancies in common. C, spouses, with some exceptions, share property acquired during the marriage, but not what each owned beforehand. Or D, all property acquired following marriages becomes jointly owned without exception. All right, Miss Cindy and Lisbeth on the ball here. Ready for their state exam. So yes, so number 1 is C, Texas community property state. Spouses, with some exceptions, share property acquired during marriage, but not what each owned beforehand. So remember, there's 4 types of ownerships, right? Severalty. Okay, 4. Severalty, tenants in common, joint tenants, and tenants by the entirety, which in Texas, it's community property state. So tenants by the entirety is that they own 50-50. And in Texas, there are some exceptions. Okay, so always remember that in Texas, community property state does have some exceptions. They own property that they acquired during the marriage and not beforehand. However, there are exceptions. All right, number 2. Okay, a husband in a community property state acquires a vacation property as a family gift on the first anniversary. What is the ownership status of that property? A, each spouse owns half of the property. B, the wife owns half of the property but must forfeit her share if she divorces. C, the property is shared since the conveyance was not via an inheritance. Or D, the husband owns 100% as a gift of the gift. So remember exceptions, and those exceptions apply actually to tenant by the entirety. Some of them. The answer here does. Anyone else? 16 going once, going twice. 1, 2, 3, 4, 5. Gone. The answer is D. Okay, the husband owns 100% of the gift. Remember, gifts belong to the individual. If her parents gave the husband a motorcycle, a car, a trailer, a boat, that is a gift that belongs to him. Or it was given to her, it belongs only to her. The only way that it could be converted to both if they have to make a legal change. Okay, they can do a quit claim deed if it's a piece of land. If it's a vehicle, they can go to the DMV and put both names on it. Now it becomes community property. However, if they never do that, it belongs to the individual that the gift was given to. All right, number 3. Which of the following is not an accurate characteristic of homestead laws? Okay, so 3 of them are accurate characteristics or true statements of homestead law. Vocabulary. A, homestead rights require one-time filing with the county clerk. B, homestead interests are extinguished if the property is sold. C, the family must occupy the residence to qualify for homestead. Or D, the homestead property can only be voluntarily conveyed by both spouses. So what is homestead, right? Homestead protects individual or homeowners from creditors taking over their home. That's one of the advantages, okay? Answer. No one. So homestead, so which one is not an accurate characteristic? So homestead is like, it's a legal title, a legal ownership, okay? To that, it's automatic, okay? They don't have to apply for, they don't have to go and file for it. Yes, the answer is A, correct. Homestead right require a one-time filing with the county clerk? No, it does not. Homestead is automatic if you're the owner and it's your primary residence, if we are the primary resident. Now, what we do have to go file for is to actually get the tax exemption. Okay, we go to the county appraisal district, okay, to apply for that, to the tax assessors, I think. And we fill out a one page because we could also be, 65 and older and also have homestead. It's our primary residence. So the home is already specified as our primary residence. However, to get the exemptions, we've got to go fill out a form, but not to have it be our homestead. That is automatic. So that is a legal title, okay? They didn't have to apply for it. Okay. All right, so everybody got that right. Okay, number 4. Which of the following best describes a homestead tax exemption? Oops, I just said something about it. A, an exemption from property taxation of portions of homestead's assessed value. B, a direct reduction in the homestead property's tax by a certain percent. C, a homestead property is exempt from taxation. Or D, a homestead property's equity is exempt from taxation. So that's what does have to be filed. In order to get that tax exemption, we do have to do a form. It might be able to do it now online because so much is done online. I know we can. Yes, actually, I was at a closing yesterday and the title escrow officer mentioned to my client, you can now go online and apply for the tax exemption on your homestead, and you can do it ASAP. You don't have to wait until next year. So those laws improved. Usually if a home was purchased like in January, February, March, beginning of the year, you could go and apply for it, but you wouldn't get credit for it until the next year. So what is the correct answer? Which one best describes a homestead tax exemption? Is it a tax exemption from all the property tax areas? A part of it? None of it? The answer is A, an exemption from property taxation of portions of the homestead's assessed value. Okay, because there's different areas of the taxation. You have city taxes, school taxes, the independent school district, and roads and planning. There are different sections to property taxation that have a percentage rate. and then they come up to a total. Like, let's say it's a 2.5%, okay, of the assessed value. Okay, of the assessed value, not the current market value in the real estate market, because that changed, and that is determined by the decision a homeowner and a buyer come to. So of the assessed value by the county assessors. And it's done by the county assessors, not a city assessor. It's the county taxation. All right, so we had, let's see, we had an answer of C. C says a homestead property is exempt from taxation. No, it's only exempt from portions. I'm not exempt, I'm sorry. It has a reduction, okay, of the tax amount from portions of the homestead's assessed value. All right, number 5. So let's see what it says here. Essentially, the homestead tax exemption is a tax reduction for a homestead property. The reduction is achieved by exempting portions of the assessed value from applied tax rates. All right, number 5. Which of the following is an accurate homestead tax exemption statement? So an accurate homestead tax exemption statement. Okay. So they are exempt from certain taxes. And then there's other exemptions. Okay. VA exemption, 100% disabled, a certain percentage disabled, 65 and older. Okay, which of the following is an accurate homestead exemption statement? Okay, I had somebody make a comment on this about, I think it was San Antonio, and I looked it up and he was accurate. But according to this book, okay, so a 10,000 exemption from county for county purposes. B, a 15,000 exemption for school district. C, the standard homestead amounts are granted to each family member resident. Or D, disabled persons can receive more than one residence homestead in a year. So when we have answers like these, we have to select the best answer, okay, that applies to the question. The actual statement in the county assessors or homestead tax law exemption is different. So keep in mind that state laws do change. This was published last year. And I don't know if that particular law changed within the last year. So the actual exemptions for school districts, okay, according to that mentioning that this gentleman cited, and I researched, is higher. But the answer, according to this question, is B, a 15,000 exemption for school districts. I'm thinking it mentioned up to 40,000. Yeah, I can't remember. I'd have to look it up again. You know, I looked up exemptions, homestead exemptions for school districts, okay? In our particular county where I'm at, and it's Bear County, not spelled like bear, B-E-A-R, but B-E-X-A-R. All right, number 6. So when that happens, okay, then we actually go to the tax assessors, the county tax assessors, and we apply for it, and you know, they apply the right exemption. We're on number 6. Okay. Oh, that's a long one. Following the tax sale in a foreclosure proceeding, a homeowner can regain full ownership of the property by paying all amounts owed plus fees and charges. Yes. In this scenario, which of the following is true? So following a tax sale, what kind of tax? Property tax sale. Okay. Property taxes are first priority in a foreclosure, and the county can foreclose a property for unpaid property taxes, even on multi-million-dollar homes. And if they owe, thousands of property taxes, it can be foreclosed, and they will foreclose it and sell it at the court steps. Okay, the first Tuesday of every month. It's typical. Could be a different date. So following the tax sale in a foreclosure proceeding, a homeowner can regain full ownership of the property by paying all amounts owed. That means all the taxes owed, plus fees and charges. In this scenario, which of the following is true? A, the homeowner may do this since he is exercising equitable right of redemption. B, the homeowner may only exercise the statutory right of redemption prior to the tax sale. C, the homeowner may in fact exercise statutory right of redemption provided the property is the principal residence. Or D, the homeowner may exercise the statutory right of redemption provided it is done within 3 years of the tax sale. So remember, these are tax estate questions. And every state has their own tax sale, property taxes that are due, that it can be foreclosed. And what is a foreclosure? Right? They're losing their property because of defaulting of taxes. If a lender does the foreclosure, they're doing it because of unpaid mortgage. So what is the answer for number 6? It's a long one, but it's a property tax sale. So there is a statutory right of redemption in Texas. So I'll mention that. And they all do mention, let's see, redemption. Okay, C doesn't mention redemption. D does mention redemption. Now that doesn't always mean it's the right answer, okay? All right, we've got C so far. Anyone else? No, it is not A. So take another attempt. The answer here is actually C. The home may be, in fact, the homeowner may, in fact, exercise this statutory right of redemption provided the property is their primary residence. Okay. The right of redemption is 2 years. Okay. The statutory right of redemption in Texas is 2 years. So they have 2 years to pay the property taxes owed, fees, other charges, and interest each year, which was, as far as I looked, was 25%. Okay. So that's on their primary residence. So it said the right of redemption refers to one's ability to reclaim the property even after the foreclosure sale takes place. The right of redemption is only available for specific kinds of foreclosure actions, such as foreclosures on certain tax liens and property owner association assessment liens. So homeowner associations can also do a foreclosure sale, and they have a right of redemption to get their property back after they pay all the HOA dues, right? Homeowner association liens. All right. So then let's see. We had an answer of A. So A, the homeowner may do this since he is exercising equitable right of redemption. So equity of redemption, known as redemption of equitable right or of redemption, is a defaulting mortgagor. So that is the owner who defaulted their right to prevent foreclosure proceedings on the property and redeem the mortgage property by discharging the debt secured by the mortgage within a reasonable amount of time. So this is done prior to a foreclosure. The lender will allow them, okay, their equitable redemption period to, reclaim their property, okay, to clear that, cure the situation, and pay their mortgage payments, fees, attorney's fees, late fees, whatever is being charged, okay, foreclosure fees, and remove the process of foreclosure. So this happens before foreclosure, okay? They have the right to be able to stop a foreclosure by paying all that debt. So it is not A, because this has to do with tax sale. So it's not because of a mortgage, it's because they didn't pay the property taxes, right? As I mentioned, even though the home and the property is paid for free and clear, we still pay property taxes, except for a 100% disabled veteran or certain businesses or individuals that are given that exemption. Some businesses that come to a city are offered an incentive to come into the city and are exempt from paying property taxes for a certain number of years. After that, then they start paying taxes. Because taxes is what helps the city go round, right? All right, number 7. Which of the following agreements, I need to type the answer over here. Which of the following agreements are enforceable? A verbal 30-day month-to-month lease. B, an oral agreement to buy an oil interest in a property. C, a written lease signed by a landlord's son and unauthorized representative. D, an oral property conveyance between a judge and a juror. So which agreement is enforceable? Right? There's certain agreements. There's a certain agreement can be for less than a year, right? And anybody who's signing their name has to be authorized, right? If it's not the actual individual, then it's by an executor, by an administrator, assigned by a court, or by a power of attorney, right? Some other right. So far we have A. So anyone who just came on, we're doing Texas state questions. And for all of you that are watching on YouTube, hey, send me some love. I don't see that many thumbs up. I only see 3 thumbs up. Send me some love and click the thumbs up. Now, if you don't find it useful, you probably wouldn't be here, right? So let me know you like it. If you don't, hey, just let it go. The answer is A. A verbal 30-day month-to-month lease, right? Because a lease less than a year can be verbal. Less than 1 year. Okay. So month-to-month lease is less than 1 year. All right. Number 8. Okay. Let's see. Lisbeth, you answered D. Let's look at D. An oral property conveyance between a judge and a juror. Okay. An oral property conveyances between a judge and a juror. Conveyances is a legal transfer of property, a legal right to transfer of property from one individual to another. That has to be done in writing and recorded. So it is a verbal 30-day month-to-month lease that can be enforceable. A property conveyance is a written instrument, okay, warranty deed. That's how a property gets conveyed. Or a quitclaim deed, okay? Number 18. But remember, the quitclaim deed has no warranty. So whoever's receiving it better make sure there aren't any encumbrances, any liens. Any liens, any encumbering into their property, fences, buildings or whatever. All right, number 8. Which of the following is a legitimate power granted to a landlord or a tenant? A legitimate power. They'll be protected. A tenant's right to vacate week-to-week rental with at least 1 day's notice. B, a tenant's right to apply the security deposit to the last month's lease in the absence of damage. C, landlord's right to evict a month-to-month lease tenant with 30 days advance notice. Or D, a landlord's right to waive liability for not maintaining habitability of the premises. So which one would be a legitimate power granted? Okay. A power that they can officially do and be protected by law. By ordinances or by zoning or rights or landlord tenant rights, acts. So many things up there to protect out there, okay, to protect the consumer, the public interest, individuals' rights. No answers? Type your answer in the chat. Maybe you've got a delay. No answer. Coming once, twice, gone. The answer is C. Landlord's right to evict a month-to-month lease tenant with 30 days notice. That is a legitimate power. So the landlord's right to evict a month-to-month lease tenant with 30 days notice. So the 30 days lease over here, right, is enforceable. So a landlord will still give them a 30 days notice that they want the property back. So they want the property revert. They want to take possession. So that was number 8. Okay. All right. Number 9. Which of the following is true regarding subletting? What is subletting? Rental property. A tenant may freely assign unit if lease is for more than 5 years. B, tenant may assign. So, when you're reading these, think about it here. Okay. Does the average tenant stay at a property for 5 years? Not typically. Some do. We move around nowadays so much that sometimes, rentals are, a month, 6 months. So, keep things something like that. Would it be for 5 years? B, it could be commercial. It could be, but this is a subletting a rental property. It could be residential, commercial, right? B, tenant may assign or sublet, but must return property to original condition prior to the subtenant's occupancy. C, tenants are free to assign their lease obligation, but may not sublet with the landlord's permission. D, tenant must obtain landlord's prior consent to sublet the apartment. Okay, so this is dealing with residential tenants. So what is subletting, right? You have the primary tenant and they've got to leave. So they find someone to take over their lease. So that is, they have a substitute tenant. They're subletting. They're letting a substitute stay in their lease that they have an agreement with the landlord. And yes, the answer is D. Okay. Tenant must obtain landlord's prior consent to sublet the apartment. It it may be already specified in the lease agreement. However, still want to inform the landlord, right? Because you're going to be leaving and landlord has the right to know. It's almost like, vacating, breaking the lease, but you're not. And informing the tenant, hey, now certain so is so-and-so, right? John Doe or Mary Doe is now taking over my apartment. Yet he's going to say, yes, but you're still responsible, right? For payment and condition. Yeah, I understand. And so they go to their buddy or their friend or whoever. You remember, you better dang pay that rent because I'm responsible. So you do it with someone that we trust. Yeah, so the answer was D, right? Yes. Very good, very good. All right, number 10. Oh, I'll make it even bigger. See if Number 10, which of the following is not, not bold, capital letters, a landlord justification for keeping a tenant's security deposit? A, to eliminate normal wear and tear to the apartment, including painting and carpet cleaning. B, to offset rent owed by the vacating tenant. C, to repair damage to the plumbing system. Or D, to cover excessive damage caused by a dog, even though dogs are permitted. So which one is not a justification for keeping a tenant's security deposit? So there are 3 of them that are justifications that a landlord has the right to keep the deposit for. One of them is not. Because as landlords, property owners, that we have investments, we have certain rights on our properties that we have to provide to make money from, right? We're providing it to individuals that are going to live in it or, have a business in it, occupy it. So we have certain responsibilities as a landlord. And we take care of our investment, right? So which one would be the best answer? And yes, to eliminate normal wear and tear to the apartment, including painting and cleaning. So a landlord's responsibility is to, keep it fresh and clean and appealable, right? Marketable to anyone else who wants to move in. So you repaint, redo the floors, get the carpets clean. Now, there could be a deposit for cleaning that is asked for in case a tenant leaves and doesn't have time to clean it, right? That's a cleaning deposit. But for normal wear and tear, that's normal maintenance responsibilities that landlords have. Unless it is a business triple net type of lease where the tenant has to do the maintenance. So those are called like triple, net lease or double net lease or triple net leases. So that's for commercial properties. So by maintaining the normal wear and tear, we're maintaining the value of an investment property. We want to do that. So after every tenant leaves, and especially if the market is improving, we want to provide a, beautiful or clean or freshly smelling apartment. Carpeting and painting, that's cosmetic. So it's less expensive. You can put laminate flooring if it's going to be with animals. If you're going to allow animal, landlords will put laminate flooring or tile. Compare the life of certain things that are going to be implemented in that apartment or that unit to get the best turnaround, best return on investment, ROI. All right, so we've been on here an hour, 52 minutes. So would you like me to continue 8 more minutes, quit at noon, or call it a day. We've done 10 state questions, and I think we did at least 10 national questions. So you tell me, this is our last day, last class, last interaction of the year, but not the last. So let me know if you'd like me to do a few more questions. I'll wait a moment. And anybody watching on YouTube, hey, remember to go give me that thumbs up if you find this video useful, this prep class. And if this is your first time to my channel, YouTube Agent Prep, remember to click that thumbs up. Okay, remember to, crooked hat. Remember to click that thumbs up. I'm sorry. Click that subscribe button, click that little bell so you're the first to get notified every time I go live or I upload a new video and shorts. I've started uploading shorts. And click the thumbs up. You find my videos useful to help you in preparing for your real estate exam and learning the material. So Miss Cindy says yes. All right, then we will continue. So let's see, should I make myself smaller? I might try it that way. Okay. So let's go to number 11. Oh, that's a little bit long one. And I admire all of you who are here on New Year's Eve, right? Many of us are staying home. And, you know, we can do our going out fun in the afternoon, but you're dedicated to do what? Pass your exam, as the thumbnail states. You can do it, you can do it, and then you say, I did it. Okay, I did it. You visualize, I did it, I did it, I did it. I passed, I passed, I passed, right? Yes. All right, number 11. In maintaining proper relations with tenants, landlords and tenants are obligated to meet certain apartment security standards. Which of the following accurately identifies one such standard? Okay, security standards. So maintaining proper relations with tenants. Landlords and tenants, there are landlords and tenants laws. Landlords are obligated to provide certain things and tenants are obligated to do certain things. So each side has specific performance, kind of like in the contracts of purchasing property. So A, is that tenants may alter security device, but at their own expense. B, landlords must install window locks in occupied buildings. Tenants must install security bars on glass doors for glass doors. C, all security devices must be repaired within a 30-day time frame following a tenant's written notice of the despair, or the landlord must rekey the locks within 7 days following a tenant's vacating. So what is it that landlords and tenants are obligated to meet certain apartment security standards? Okay, so which ones refer to security standards? Well, they're all dealing with something of secure, but who provides it? Who does it? And timelines. So landlords have certain things to do when it comes to security. You know, they have their smoke detectors, fire extinguishers. You know, those have to be certified every year. The fire extinguishers, right? Get them inspected, make sure batteries are changed on smoke detectors. And some have ladders as an escape, you know, out of windows. So it depends. Oh, and then of course, locks, you know, double locks and making repairs when notified. Here, the best answer, which of the following accurately identifies one such standard? So when a tenant vacates, a landlord has within 7 days, D, following a tenant's vacating, to rekey the locks, right? Because they're going to end up renting it to somebody else. And what if they immediately rent it? They had their their maintenance guys, their subcontractors, okay, all their team come in and get it done in a day, then they better do it ASAP. So they're given up to 7 days following a tenant's vacating that property and the owner getting it back to change those locks, right? So the old tenant can't come back in when there's a new tenant in there. So they're providing security to the incoming tenant. Tenant, occupant, different words. So when the owner takes possession, it's called what? It reverts back to the owner when the tenant leaves. If they're going to end up leaving it to somebody else, it goes to whom? The remainder man. Just adding some other words in there, okay? About property ownership or what happens when a property is vacated. It can revert or it can go to a remainder man, a remainder person. Number 12. All right. Okay. I don't know who that new person that showed up. I have no idea what the name is. So something I don't know, said yes. So if you're here to prepare for your test, welcome. All right. Number 12, Texas Property Code Chapter 92 is very specific about fire safety regulations. According to that code, A, there must be a smoke alarm on at least the ground level of a 2-story building. B, the fire alarms must be inspected annually by the landlord. C, tenants are responsible for inspecting and repairing fire extinguishers. Or D, there must be a smoke alarm in every bedroom of a dwelling unit. Security, depending on when major disasters happen, some securities are increased and therefore are implemented, on all buildings, homes, ordinances, zoning. So older properties that maybe didn't have it, they're kind of grandfathered in. However, when it's conveyed, they're improved, and there's an inspection where they have a city inspector come in, they're going to require the current code, the current ordinance. And let's see, what do we have here? DD. Yes, the answer is D. So anyone that just showed up, we're doing Texas state questions to prepare for your Texas real estate sales exam. And these questions have to do with special topics in the Texas real estate. All right, number 13. Yeah. Okay, so let's see if I go. That should work. All right, 13. Utility service to tenants is regulated by Property Code 92. One of these regulations is that A, tenants are responsible for all utility charges if the apartment lease exceeds 1 year. B, tenants may not pay a landlord's utility bill to avoid any service interruption. C, the landlord may not cause utility service to be interrupted to the tenant as a means to collect unpaid rent. Or D, if a tenant is forced to pay a landlord's water bill for the apartment, the tenant nevertheless must continue to pay rent in full. So Property Code 92, right? Most of us probably don't know the property code. Is it something that I regularly use? No. Okay. However, when you're preparing for this, you were taught certain things and you're required to remember. Or if you don't remember, then you take a guess on this question. And sometimes when we're guessing, we look at what the 4 prior answers were and we can pick that. That's sometimes how they go about saying that if you don't know something and you want to guess, look at the prior 4 answers and take a guess that way. Doesn't always work, but it's a good risk to take, a good chance to take it and get it right. So number 13, so we've got Cindy with C. Anyone else? And remember, you can always mark the question for review and come back to it later and look at, hopefully a future question will help you, or you can go back and review other questions that will refresh your memory to select the right answer for the particular question you're on. Do not take a lot of time. You typically have, a minute and a half for each question. So go and do all the easy questions first, and then come back to the difficult ones. All right, so we have a success here. Pass my national. Thanks, Lily. This is Vicky Hubert Smith. Okay, she posted on Facebook. Congratulations, Vicky. You're the second person that passed today. One other gentleman, Rene, passed both as state and national on his first try after starting doing real estate studying from 10 years ago, and finally got it done. So congratulations to you. So excited for you. A great way to end the year and start next year by choosing a sponsor. So remember to interview with different sponsors, including you can interview with me at eXp Realty and see if a virtual company works for you. Just review and questions a lot. Ask a lot of questions to different brokerages and see which one best fits your needs. So you're complete. Awesome. Congratulations. So the answer here, yes, is C. The tenant, so the question, utility service to tenants, water, gas, electric, is regulated by Property Code C. One of these regulations is that C, the landlord may not cause utility service to be interrupted to the tenant as a means to collect unpaid rent. We cannot shut off the utilities, right, to force a tenant to pay. We're supposed to provide a habitable unit, including heating, water, gas. And we have to follow the legal way to get a tenant to pay or evict them. Now, there are shady landlords that do that scare the tenants, and tenants don't protect themselves, okay, because they don't know their rights. Or they could be illegal, undocumented, and they can't go and complain and use the rights of the area, the rights of the state. So individuals, landlords take advantage of individuals like that. It happens a lot, unfortunately, for illegal, undocumented individuals, which we have many in Texas. Hardworking individuals, getting a better life for themselves. All right, so landlord can't shut them out, can't lock them out. Have to do it the legal way. Go knock on their door or go to court. Number 14. Leases may be terminated in legitimate ways. Oh, Vicky, would you type on here what you studied, how often you studied, and how many times you had to take the exam? What did it take for you to pass that national exam? Would greatly appreciate you sharing with everyone else what it took for you to pass. Did you study your prep books, YouTube channels, hire tutors, hire schools, prep schools? What did you do to help you finally pass? All right, number 14. Leases may be terminated in legitimate ways, okay? Legitimate ways, or by other means which may be unlawful. Yes, I mentioned. Which of the following is a perfectly legitimate cause for lease termination that does not carry a legal or financial liability? A, abandonment. B, conveyance of the property by landlord to another owner. C, death of the tenant. D, expiration of the lease term. So which of the following is perfectly legitimate, correct cause for lease termination that does not carry a legal or financial liability? So remember, there is a lease with requirements of both sides of the party that have to perform. Otherwise, there are consequences. So far, we have D. Anyone else? D. Yes, the answer is D, expiration of the lease term. And you might ask, well, how come there is, when someone dies, I mean, they're no longer there. Yeah, they may have a will and estate, and that estate will have to take care of the lease, okay, of them passing away. Let's say when they were just 6 months into the lease, 3 months into the lease, and they had a year lease. So the landlord is still due that financial responsibility, even though the individual passed away. So whoever is taking care of their assets will then take care of the landlord's financial requirement. All right, number 15. When tenants default, the landlord may evict by following the correct procedures. That is correct. Landlord-tenant laws. Which of the following action would be considered proper eviction procedure? Okay, we have to follow proper procedures in order to do an eviction correctly. A, the landlord with or without proper notice can lock the tenant out of the premises. B, the tenant files a suit for possession. C, prior to filing suit for possession, the landlord gives the tenant 14 days written notice following default where tenant does not vacate. Or D, armed with a writ of possession, the landlord gives notice of the demand to vacate, including removal of personal property. So, right, if you're doing a legal eviction, there are steps that have to be taken, right? And go to a local district court, okay? A smaller courts. Most cities have a local justice of the peace, and decisions are made quicker than going to a major court that can take, weeks or months. So what does it take, okay, to take back possession or to evict someone? Which of the following actions can be considered proper eviction procedure? Okay, so far Delta says D. I forgot your name, Delta, so hope you're okay. Delta Airsoft. It is not C, Miss Cindy. So when tenants default, the landlord may evict by following the correct procedures. Which of the following actions would be considered proper eviction procedures? So they're going to evict them already. Well, they say may. They may evict them. They're not saying they're must going to do. So the tenant defaulted, and the landlord has the right to maybe evict them or give them a chance to cure the situation. Yes, the answer is D. So the best answer here is armed with a writ of possession, the right to possess, the landlord gives notice of the demand to vacate. It's a demand to vacate. Okay, they've already gone to court. Now they have this document, writ of possession, including removal of personal property. And usually a sheriff will go and get that taken care of and give them, a few hours to finally vacate. No argument, no nothing. It says, hey, you were given an opportunity to vacate. You didn't do it. So here is to force you out. This is a demand to force you out. Your options are over. And I know that by personal experience, that tenants still wanted more time. They said, no, you were given enough time. This is a tenant that was quite savvy about the tenant-landlord rights and very good at abusing the system. Used to work in the system and learned, okay, the loopholes, the tricks. So number 16 is D. Armed with a writ of possession, the landlord gives notice of the demand to vacate. So when it finally gets to writ of possession, okay, they've gone through the other options where they had a hearing, they could, complain, give their side of the story, cure the default. So C said, prior to filing a suit of possession, the landlord gives the tenant 14 days notice following default. The landlord can give them, 24 to 72 hours in order to cure if they're default on payment, or if they have a dog there that's not allowed, or they've got people there staying, or they're doing something against the lease agreement. The landlord can give them 24 notice to cure it. 48, 72. Okay. And they have to put a specific date and sign it, hand deliver it, or post it on the door, mail it, all the options to make sure all are covered. It's probably best. And if that doesn't happen, right, then they're filing an eviction notice at the local justice of the peace, the local court, and start the eviction process. The tenant has a right to ask for a hearing, okay, and contest it and go to the hearing. So that's why sometimes evictions can take 30 to 60 days or maybe longer, because it has to be, with the hearing of the local court, justice of the peace. And then, they show their argument, landlord shows their argument. If somebody doesn't show, then it's defaulted. All right. So, so that's it. All right, y'all. So we're calling it a day. And that was the last question. We did 15 Texas State questions. So I'm going to wish you all a happy new year and more of you to pass that exam and become realtors in the year of 2023. This is your year. So remember to affirm, I passed, I passed, I passed. Thank you so much for attending. I hope my sessions helped you. And I love you all. Believe it. Okay, ask it, believe it, and receive it. This is Wild Lillie Handy coming to you from San Antonio, Texas with who? YouTube Agent Prep. So if this is your first time to my channel, hey, tap that subscribe button, click that little bell so you're first to get notified, and like this video by clicking the thumbs up. Until next time, until next year, 2023, catch you all later. Celebrate.